Janet Ray. Oh, so we don't have to. For later.
Good morning. It's great to have you all here. I wanted to just welcome everyone and say that we appreciate you coming. And it's when I look around, I see many, many special guests here today. But if I start introducing some of the special guests, I am certain I will miss a few others. So just suffice to say that we appreciate you joining us for this very special time here in Visalia. We try to take our Court of Appeal on the road occasionally. We're based in Fresno, have been based in Fresno for about 50 years. We're celebrating our 50th anniversary coming up. The Court of Appeal justices used to basically hit the road all the time and travel throughout the state. And until about 50 years ago, we had traveling justices who would come to Central California. We cover about 9 counties in Central California, so every time you have a trial or a proceeding or a pendency hearing that is appealed that comes to the Court of Appeal, it comes to us from these counties. And oftentimes a court proceeding could be a couple of hours or it could be a couple of months. And that entire couple of months of trial can boil down to what you will see here today, a 30-minute hearing. Now, at a proceeding like this, it is unlike what you see on TV. When you see Law and Order or Perry Mason or Matlock, oftentimes you will see pivotal moments where someone stands up and points to someone as the culprit, or some other dramatic point in time that turns the course of events. That doesn't happen at the Court of Appeal. We think it's exciting, but it's more exciting in terms of legal arguments. We'll be hearing the attorneys argue the legal nuances of what happened during the case and during the trial. You know, I was looking, and it's really a special occasion here to have so many high schools represented, and I think, let me see if I have everyone covered. We have, first of all, the College of Sequoias, which is great, Exeter High School, Farmersville High School, Golden West High School, Granite Hills High School, La Sierra Military Academy, Lovell High School, Mount Whitney High School, Orosi High School, Strathmore High School, Tulare Union, and Woodlake High School. Did I miss anyone? Well, welcome. Again, it's great to have you here for this court proceeding. Now, we'll be having an opportunity afterwards to ask questions of the justices who will be proceeding with the case very soon. And so you can ask all of them questions, all of us. I'm currently the presiding justice for the 5th District Court of Appeal. And we have with us as well, I believe we have Justice Kane and Justice Franson. In a moment, Justice Franson will tell you a little bit about the facts of today's case, what you'll be hearing about. And so at this time, without further ado, I will introduce Justice Franson, who's the newest member of our court, having joined us about 3 months ago, I believe. He came to us from the Fresno Superior Court, where he was a judge there, and before that in private practice in Fresno. So it's my pleasure to introduce Justice Don Franson.
Good morning. I know nothing about this case personally. On the Court of Appeal, justices sit in groups of 3. You're going to hear 3 justices today hearing this case. And under the rules, they don't talk to anybody about the case except among themselves. And so what I'm going to explain to you is just a little summary of some of the facts of the case that are included in the packet that I think everyone received. And for those of you who have not had an opportunity to review the packet, I thought I'd just give a very short summary of what the case is about so you would feel comfortable listening to the proceedings you're going to hear this morning. This is an appeal from a criminal case called the Herrera. And that case focused on a family party in honor of a 3-year-old boy who was having his birthday. The victim of the party was at the party, and the victim of the crime was his uncle, Mr. Huerta. Mr. Huerta came to the party along with an acquaintance of his, the defendant, Arminio Herrera, who was intoxicated. And because of his behavior, he was asked to leave the party, which he did, but he returned shortly thereafter with a small knife and began stabbing the victim. He fled and was later arrested and charged with attempted murder and assault with a deadly weapon. A jury convicted him of those crimes, and we're here on appeal today for that case. The two major issues in the case are whether there was substantial evidence to find him guilty of these charges, and whether the trial judge properly instructed the jury on the law of the case that they applied in their deliberations and in reaching their verdict. With that in mind, I think we'll proceed.
Thank you, Justice Franson. At this time, we'll have the justices who are hearing the case, Justice Wiseman, who's the acting presiding justice today, Justice Detchen, and Justice Cornell, who will be the three panel members. And we'll call the court to order.
All rise. Court of Appeal for the State of California, 5th Appellate District is now in session.
Right, good morning, council. Ladies and gentlemen, please be seated. We are on the record on the matter of the People versus Armenio Huerta. It is our case number F059689. On behalf of the Court of Appeal, we welcome all of you, and we are especially appreciative of the attorneys that are appearing with us today. Counsel, I would ask that you would announce your appearances and advise our audience of the name of your client. You may begin. I also see that both of you have requested 15 minutes, and Ms. Gray, since you will be speaking twice, would you like me to let you know, let's say, when you have 5 minutes remaining?
That would be perfect, Your Honor.
Okay, I would be happy to do that. You have enough on your mind right now.
That was the first thing I was going to, that was the biggest part of my argument, so.
That's good. Well, we've already got that covered. You may begin.
Okay. Thank you. I'm Janet Gray. I'm appearing on behalf of my client, Armenio Huerta. And as mentioned, I would like to reserve 5 minutes for rebuttal. I'm going to direct my comments to the instructional issues in the case. And initially, the voluntary intoxication instruction was incorrectly limited to mental state in this instant, and under the circumstances of this case, that was incorrect because Mr. Huerta was highly intoxicated. It's not disputed.
And counsel, when you use the term instructional issues, what do you mean by that? As the court knows, and most of our audience, or several members of our audience may not, is that every jury is instructed with the legal principles that apply to the case. And the instructional issues are a frequent hotbed of appellate litigation in criminal matters because of the changing nature of the law, and also because of the principle that such instructions actually are not set in stone. They need to be adapted frequently for the circumstances of a particular case, such as I was stating in this case, we have a highly intoxicated defendant who the evidence indicated he was about 0.26 at the time of the incident, and he was interviewed extensively by the police in an unrecorded statement that lasted some 60 to 90 minutes long while still intoxicated. And
isn't your concern that he was allowed to talk too much?
No, not at all. I'm just saying it was a lengthy discussion while he was intoxicated, and some key statements were taken from that long discussion. I think that the issue is the actual instruction
which told the jury directly to disregard evidence of intoxication as to any issue other than mental state.
Well, what you're seeking isn't instruction, or what you thought would have been appropriate is an instruction that intoxication would require somebody to be less than truthful. Otherwise, it's really not too relevant, isn't that right? Because you want the instruction so that the jury would disregard the statement that he made to the police.
Well, not so much disregard it, Your Honor, as to look at intoxication in terms of how significant is this statement, in as much as the state is using that as key evidence to establish his state of mind to prove both intent to kill as well as the deliberation in the case, the deliberation facts. They extracted that he said, I wanted to kill him. They extracted, he said, I wanted to stab his heart. And when the jury's told, do not consider intoxication for any other issue other than specific intent and deliberation, I think the jury, the principles are, they're going to follow the instructions.
Well, what I'm grappling with here is that the intoxication you speak of, I think it's general knowledge that when you have a lot of alcohol in your system, you become less inhibited, not more inhibited. And so I expect you're going to be less deceitful instead of more deceitful. So aren't we back to my original position that the instruction you're asking would have told the jury to disregard the statement because it was too honest?
I'm not sure that intoxication is necessarily a truth serum. I think that much of his statement, you could attribute intoxication also to simply bragging or being, since this intoxication was severe, there's a question of his actual state of consciousness at the time.
And that was argued, wasn't it, by his counsel?
Only an argument with an instruction to the jury to disregard intoxication as to any other issue. And I've cited cases in the brief that say that when defense counsel is forced to argue an issue or his theory without support of proper jury instructions, it actually detracts from the argument because it creates the appearance that his argument is without force of law.
But counsel, aren't there also jury instructions, one in particular that gives certain factors that may be assessed by the jury in determining credibility? And the fact that someone is intoxicated, unable to perceive events in an accurate way, would it not be covered by that type of instruction, getting to the point of whether having had an instruction would have made a significant difference?
Well, in this particular instance, Your Honor, that instruction was not adapted for this, and I did come prepared with what I would call suggested instruction that would have been fairly simple to add, and that, if I could read that, and that would be with, however, intoxication may be considered on the issue of witness credibility, including defendant's statement to police. And getting back to Justice Cornell's question, I wanted to conclude with, I understand your concern, sir, but I think one of the strongest cases in support of my position is actually the Supreme Court case cited in my brief, Mendoza. And that I have that citation, but it's also in the brief, both the opening brief and the reply brief, 18 Cal 4th 114. And I would like to clarify for the court, I cited it at page 24 in my opening brief, and I would like to point out it was unintentionally omitted. That citation is the concurring opinion of Justice Mosk.
We're aware of that.
And thank you. I didn't state it, so I wanted to make sure there was no misunderstanding. And I apologize for not mentioning that, but nevertheless, it was a concurring. But he does point out, well, initially, I would like to point out that the the majority opinion does state that where the court does decide to instruct on intoxication, it has the sui sponte duty to do so correctly. So it's not really an issue of forfeiture, as the respondent argued in their brief. And
Ms. Gray, tell me when a court does have a sua sponte responsibility to instruct on that. Is it when there's evidentiary support for it?
well, I think that, I understand, like, from the basic instructional duties, I think I went into quite a few of them in my reply brief, like the Fish case and the LA Dodgers case cited, is that, instructions may, while facially correct, when there's certain facts presented by a case, somebody has to look at it and say, hey, wait a minute, if we tell the jury this, they're going to think that the fact that defendant was intoxicated when he spoke to police has no bearing on anything. And as the defense counsel argued, he was bragging and during that statement and a little bit out of his mind. So whether or not he was telling the truth is hard to say. But I think the important thing, though, that I pulled from Justice Moss' concurring opinion in the Mendoza case on the intoxication issue in relation to the aiding and abetting is that it's not really a function of Penal Code Section 22 limitations when you're talking about an issue outside of specific intent. You're talking about Justice Moss got to the same place as the Mendoza decision that intoxication was relevant to the issue of aiding and abetting in that particular case. But he did so in a much quicker path, and he said it has to do with intoxication is always relevant on issues of credibility, and that's cited, and he cites to the case also cited in my brief at page 24, People versus Barnett. So it's really a question of credibility, and that was not
Isn't this a little bit of a two-edged sword? By that I mean virtually the only evidence of your client's defense in this case came in through those very statements that you're now asking the trial court to instruct the jury to take with a grain of alcohol, so to speak.
I think it's a grain of salt.
Well, Your Honor, that's
It's all alcohol.
That's true, but I think that because it was the cornerstone of the prosecution's case, and the statements that were the most memorable, and I would point out that it sort of got lost in the presentation of those facts that he made those statements. I wanted to kill him, and I tried to go for his heart after he was lunged at. After he was attacked by the alleged victim, Mr. Huerta. So, I think the jury should have been instructed correctly so they could consider the validity of the entire statement. And I'd like to make just a brief statement before I run out of time on the voluntary manslaughter instruction that was omitted under sudden quarrel or provocation. And, a lot of times as an attorney, I go back to the basics when something's not on point, and I have to go to Breverman. And Breverman says, if you look at the facts from Breverman, what was involved in that pivotal case was a group of people being assaulted in a parking lot over a relatively trivial matter and defending themselves. And the Breverman court said that when you're assaulted, that will give rise to provocation, rage, and all the things that make up the sudden quarrel factors. So if the trial court is not the person to determine whether or not appellant's claim that he was lunged at was correct, that's really a jury question. And under similar facts, Breverman found that being assaulted is also a basis for provocation. And I would like to point out that although the jury in this case did reject self-defense and imperfect self-defense, there's an issue within that, the realm of self-defense or of the self-defense defenses, and that is that a factor that has to be proved is that the defendant actually believed that he was in imminent danger, which is not presented by the provocation. So, and that's also discussed in my brief with the case site.
All right, counsel, you have approximately 5 minutes remaining. We'll reserve those for you.
Thank you.
Thank you very much, counsel. And next, we'll hear from Ms. Jacobs. Good morning, counsel.
May it please the court, my name is Sarah Jacobs. I represent the people of the state of California in this case.
Counsel, would you bring the microphone down just a little bit and make
Is
sure
that
you
better,
speak?
Your Honor?
Yes, I think so.
Thank you. Going straight to appellant's argument on the third issue here regarding the voluntary intoxication instruction, the people would like to point out that the complaint of instruction, CalCrim number 625, the title of the instruction itself clarifies that this voluntary intoxication relates to the effects on homicide crimes. This has nothing to do with the credibility of the defendant's statements. Quite plainly, had the defendant wanted a clarification of the issue of his intoxication as to his statements, Mirandized statements made to officers, he just plainly should have asked for one. He did not do so in this case and thereby forfeited this issue.
But counsel, assuming that is true, then why would this not then be a candidate for a claim of ineffective assistance of counsel if we were to follow your reasoning?
Yes, Your Honor. Under Strickland, the two prongs of ineffective assistance of counsel clearly state that there is a separate reason when an IAC or ineffective assistance of counsel claim would not be met, and that's for a tactical reason. In this case, the defense counsel's entire strategy throughout the entire trial was that he was only guilty of the assault with a deadly weapon, that he was not guilty of premeditated attempted murder. That was his entire strategy. So the tactical reason for the voluntary intoxication instruction would be to negate the mental state required for the premeditated attempted murder. And that instruction 625 and, and 3426 both go to that. So the ineffective assistance of counsel claim, while not made by appellant, would not succeed in this case because it was a strategy decision.
Might not another tactical reason be that all of the evidence that supported that position came through the statement, the very statement that he gave to police?
I'm sorry, Your Honor, I didn't follow your question.
The defendant's or appellant's statements to police was contained virtually all of the evidence that supported the defense that you were trying to say that the attorney was putting forth.
The only two witnesses that observed the attack were the victim and the defendant. No one else at the party observed that attack. The defendant's statements, yes, do relate to his intoxication. However, every witness at trial did in some capacity testify as to the defendant's intoxication.
But what I'm getting at is you mentioned a tactical reason, and I'm saying might not another one be that if he killed the statement through the intoxication instruction, he'd also kill the evidence that his client was saying he was acting in self-defense?
Unreasonable self-defense, yes, Your Honor. However, appellant attempts to claim that the defendant, quote unquote, attacked him and lunged at him. However, the statements made by the defendant to officers were specifically that, quote, he did not attack, the victim did not attack defendant, merely that he, quote, lunged at him. There is no evidence that he attacked him in any way, shape, or form other than a mere lunging. And that, under moving to the heat of passion theory, is not sufficient provocation to warrant the response by defendant in this case. If defendant's statements are believed or credited, contrary to the victim's statements. He lunged at, the victim lunged at defendant after defendant repeatedly asked him if he wanted him to kill him, and apparently, according to the defendant, the victim said yes. And then with the knife, he stabbed the victim once in the abdomen, in the upper right abdomen, in a vital organ area. And the second stabbing attempt occurred on the right arm as the victim went to protect himself. Both of those show a clear intent to kill and are not, the lunging was not adequate provocation.
Counsel, could we have you address for the moment Ms. Gray's argument with respect to the intoxication? This case is somewhat unusual to the extent the extent of the statements made by Mr. Guerra that were implicating him. To that extent, Ms. Gray has raised the issue with respect to whether this case is so unusual that there should be some exception carved out in effect to take care of the intoxication issue, that this case is so different that perhaps there should have been an instruction allowing the jury to consider those statements in light of the intoxication. How do you respond to that specifically? Should this case be different than others?
No, Your Honor. CalCrim number 625 is an accurate statement of the law. All of the instructions given in this case, which are considered as a whole under the standard, deal with specific issues relating to witness credibility or how the jury should view the defendant's statements. In this case, the jury was instructed under CalCrim 358 and CalCrim 359 to view the defendant's statements made with hesitation, to view them carefully in consideration and under the corpus delicti, that he could not be convicted on his statements alone. And if the defense counsel thought that the specific facts of this case were not adequately addressed by the jury instructions that correctly state the law, quite simply defense counsel should have requested a clarification. And defense counsel failed to do so. Moreover, defense counsel didn't move to suppress these statements below. And if they had thought that they were were uncredible or unreliable, then that would have been the vehicle by which to make that claim. It was not done in this case. And moving on to the fourth issue regarding the voluntary manslaughter.
Ms. Jacobs, let me ask you about that because you were making a point about that, and I wanted to find out what your thoughts were on Ms. Gray's argument about Breverton. This trial court did not instruct this jury on attempted voluntary manslaughter, heat of passion, on that lesser included. And Ms. Gray is arguing that Breverton stands for the position, or could stand for the position, that assault is sufficient to raise a heat of passion defense. Do you wish to address that?
Yes, Your Honor. Right. First, I believe Breverman, is that the case? In Breverman, while the facts of that case were a little more egregious than the facts of this case, there are numerous cases which state that even a simple battery in and of itself does not rise to the level of providing adequate provocation to warrant somebody to respond to inflame their passions, to respond in a manner of attempted killing. To respond with a stabbing by possible lunging, there was no evidence that the victim touched the defendant in any way or attempted to attack. The defendant's statements himself were that the victim did not attack him, merely lunging, and that he responded as a mere yes when the defendant asked him if he wanted to kill him or if they wanted to fight. Those statements do not provide adequate provocation under the law for a reasonable, sober person to respond in such a manner as the defendant did in this case. There also there was no immediate response. The second prong would be that the defendant had time for a cooling off period after being kicked out of the party. The victim testified that he left for approximately 10 minutes, and the victim testified that he noticed the defendant returned to the party, but chose not to approach the defendant. He told his sister that, ironically, that the defendant was harmless.
But you're reciting evidence on only one side of the argument. What if we just, the trial court, in determining whether or not to provide the instruction, must look at the evidence, all of the evidence, isn't that correct?
Correct, Your Honor. And the defendant's statements are what support his argument that there is a possibility of any evidence for this voluntary or manslaughter instruction.
Wouldn't that be sufficient in and of itself to require the trial court to give the instruction?
If there was evidence that rose to the level of showing, but it has to be evidence that is substantial. It cannot be whatever evidence, however weak. And here, the evidence was weak. There was no adequate provocation, and there was a cooling off period. Moreover, if error, if any, was harmless, the jury specifically rejected this contention in finding the defendant guilty of premeditated murder. Under CalCrim 601, the exact statement or exact sentence is that a decision to kill made rashly, impulsively, or without careful consideration. That's exactly what voluntary manslaughter, a heat of passion, relates to, and the jury specifically found that not to be true when it convicted the defendant of attempted premeditated murder. And unless Your Honors have any other questions, the people respectfully request this court to affirm the judgment in its entirety.
All right, your timing is impeccable, and we do not have any additional questions at this time. Thank you very much,
Thank you,
counsel. And Ms. Gray, we'll have you return. And for the audience's benefit, Ms. Gray has the opportunity to speak twice in this matter and to rebut any points that the other attorney has made. So, counsel, you may close.
Thank you, Your Honors. I first would like to point out that, and just make it really clear that, yes, the jury was instructed with standard instructions regarding assessing credibility, but when you look at the instruction at issue in terms of voluntary intoxication, they were specifically told to disregard. And let me just go over that briefly. You may consider evidence, if any, of the defendant's voluntary intoxication only in a limited way. It may, and I'm going to be brief, you may only consider that evidence in deciding whether a defendant acted with an intent to kill or the defendant acted with deliberation and premeditation. You may not consider evidence of voluntary intoxication for any other purpose. So, despite the fact that we have the standard general credibility instructions, which did not include any modifications to address intoxication, the jury would be expected to follow that limitation of the use of the voluntary intoxication evidence. And that is why those other instructions do not save the day for a respondent on this issue. And as to the argument that these were should have been a pinpoint instruction, take a look at the Supreme Court holding in Mendoza, which I've already referred this court to. They cite another Supreme Court holding in Castillo, and that's at page 1134 in the majority opinion in Mendoza, that says, I mean, it's very specific. Once you're on the road of instructing with an intoxication instruction, it should be done correctly. And we assert that that's the basis on which Appellant asserts that they did not fulfill the sua sponte duty to correctly instruct. And turning to the second instructional issue, as to whether there was adequate provocation, and the respondent has argued that it's only defendant's statement that supports the assertion that there was provocation at all. He said, Huerta lunged at me. Well, I brought Breverman with me and looked at some of those facts, and granted, there was a sizable group of young men armed with dangerous weapons and harboring a specific hostile intent. But when you look at the facts of this case, that seems a little more onerous in Breverman. But we do have a defendant who's been asked to leave a party where he's a guest. There's a lot of people there who are drinking, including the alleged victim, Mr. Huerta. Mr. Huerta was not necessarily armed with a common weapon, but of like a knife or a gun, but he admitted to drinking 3 beers and was holding a beer bottle when he was approached by defendant returning. And I believe those are certainly prosecution facts that support a claim of provocation because they support. And additionally, Mr. Huerta, the appellant, their names are so similar, I want to make sure we're on the same page. Mr. Huerta did have a scratch on his face, and his shirt was examined with DNA evidence. There was blood on it, which was not the alleged victim's blood, and it was not determined exclusively to be defendant's, but it was determined. I believe the conclusion was it was consistent with his blood, which I just reviewed another case where in a homicide where that was very strong evidence to convict that defendant of homicide. So it appears that the appellant was harmed. He was bleeding and he had a scratch on his face. So there's more than his own statement that he was involved in a mutual combat situation. And I would like the court to review those facts stated in both my briefs and when looking at these instructional issues.
All right, thank you, counsel. We will take a second look at that, and we thank both counsel for their being here. What we will do is take the matter under submission, and for our audience's benefit, what that means is that starting today, we have 90 days within which to reach a decision, and at that time, we will issue a written opinion that counsel will receive, finding out what the collective judgment is of the panel. Now, having concluded the case, I would like to take this moment to thank the 2 attorneys for coming here and traveling to Visalia, and Ms. Gray, Janet Gray, I'd like to introduce her again, and also Sarah Jacobs of the Attorney General's office. It's hard enough to come and argue a case, let alone to come to a different community and argue in front of about 100 people, even though you've been a model audience. But I think they deserve a round of applause for their efforts, and we thank them. I would like to take a moment. We're going to switch gears now and hopefully have a very lively question and answer period. But before doing that, we want to introduce some people that are very important to us. Of course, you've already met our colleagues. Have you been introduced? Justice Brad Hill and Don Franson and Steve Kane, who are also very important to us. But the staff members here that got up very, very early in order to arrive here by 7 in the morning and to help make this all work. Kathleen DeSantis, is Kathleen? Yes, way in the back. Kathleen is our lead attorney, and her many responsibilities include helping get cases assigned to chambers, keeping things moving smoothly, and she is really the pulse of the court, and we're very grateful to have her here, Kathleen. And next, Charlene Jensen, also in the back, waving her hand. Charlene has to be one of the most positive individuals in the entire world. We happen to have them all here today. She is our court administrator and is just a very, very fine person and specializes in court administration. Next, we have Julie Bagoy, who is the assistant court administrator. Julie is also standing and is with us today. And Robert Abalez. Robert, gosh, we've got everybody in the back. That's probably because we only had seats in the back, perhaps. Robert is our supervising deputy clerk. And last but not least is Jeanette Zamorano, who is our assistant deputy clerk. And you've also probably noticed walking in a suit with, looking very carefully at all of you, this is Kathy Brunel, who is our CHP officer and our security officer for the court. Now, one thing we would like to do, we're going to take our robes off and become a little bit more relaxed, but I know the attorneys are here for a short period of time, and if you have questions that you would like to ask them about their jobs and how their career path worked, or any of our staff, because they all have very interesting jobs and they all followed very different career paths in order to get there, we would encourage you to do that. And so with that, Justice Hill, why don't you all come up and we'll get relaxed, and we've been told that you've sharpened your pencils or your computer keys, whatever the term is, and have questions for us, which we are looking forward to the most. So thank you, and we'll ask the instructors maybe however works best for you to get us going. And Charlene, you have a microphone, and we are being recorded, so that's one of the reasons that we would like you to use the microphone, so that people that are listening to the presentation will be able to hear your voice, and then we'll understand the answers to questions. So, Brand, would you like to be here? Okay.
There we go.
Brad, is it all right if we get started? Yeah, I see a hand. So,
I'm sorry, before I do come up, do the questions have to be relevant to the case? Or?
What a good point. In fact, that's the only kind of question that we're not able to answer. And the reason for that is that if we were to start kicking back and talking about the case, that would be unethical, even though it may be tempting to ask questions about it. You can ask questions about criminal cases in general, if you like, just not about the facts of this specific case or the law. But thank you. I should have clarified that. That's a very good point.
Thank you.
My question is for the attorneys. How long did it take you to prepare for today, or any case that you do?
Well, I'll start out with that. It's kind of hard to pin down because, there's a lot of things that you do, like if you're working in your garden or swim laps, I'll be thinking about the case, what I'm going to argue, and it doesn't necessarily get put on a claim form. So, but the actual time, the court allows us 8 hours to prepare. In terms of like what we get allowed. Sometimes I put substantially more. And this case in particular, I've argued cases with a lot more detailed facts and a lot more scientific evidence. So in those situations, it takes much longer. These facts were fairly simple. So it really varies on the case and the issues that you're planning on arguing. But, it's a good day. And I usually don't take calls or talk to people the day before. So I could focus on the issues.
The people are a little bit different. I had one moot court in preparation for this case, which means 3 of my colleagues volunteered their time to read all of the briefing. And so in preparation, I would say that I would be more prepared immediately after writing my brief in response to her initial opening brief, and then she files a reply. So all of that is a kind of a history of preparation, and then as time passes, and you put the file away just long enough to forget about it for the oral argument to come up, and then you prepare for it at that point. But yeah, as Ms. Gray pointed out, a lot of the time I do spend thinking about cases and organizing them in your mind seem to happen while you're out of the office, grocery shopping or something like that. It just falls into place as so many ideas do. So.
Mine is also for the attorneys. I was wondering if when you do take on a case, if you work on one individually or if you have others that you're preparing for as well.
You know, it's a good thing. I have to say it, I'm a little bit inhibited because there's judges here, but but yes.
Voluntary intoxication?
No, officer, I don't drink. And if I did, it was only one. But anyway, yes, we do take several cases. An appeal takes approximately a year to 2 years, depending on the length of the case and how long it takes. Sometimes the records are incomplete. You have to wait for the Superior Court to respond. Sometimes the briefing, this was a fairly short brief for me. I've written briefs this brief was about 34 pages with 4 issues. I've written 12 to 15 issue briefs that are 130 pages on large homicide cases. So it really depends. So, you know, I usually have what I call 5 in the hopper, where I'm trying, and then they go through different stages as, Ms. Jacobs. So, you know, you have some periods of waiting. So sometimes, you know, the reason why I mention the justice is because nobody in this district, but there's one that believes that that's the only case you have in Los Angeles. And so whenever you get one of those division cases, you have to be very specific about making that a priority so that you don't end up strung up and by your feet, but not literally, but you feel like that. But anyway, so yeah, you work, sometimes it's a juggle, but you know, since I've been doing this since 1985, actually, exclusively, and you know, I practiced with raising children. Doing appeals is a little more, I previously did litigation and was having to run off and joust with attorneys in court and stuff, and it was really hard when I had a couple little kids at home. So the appeals was a little easier with kids because things are paced a little slower. So, you know, it really depends. And some people will take less. It depends on your ability and, you know, how many cases they're willing to give you. And so, you know, I would say 5 before they've been briefed, but overall, because it does take 2 years and there's different stages where, you know, sometimes the respondent, I file a brief and they might take 3 to 6 months, depending on their ability to get extensions from the court before they respond. So I have nothing to do on the case in between those 3 to 6 months, unless there's some type of investigation, which we don't usually do unless there's specific facts that show that something was really amiss that should have been admitted at trial. So then you move on to another case while you're waiting for them to get their work done. And then it gets once they get their work done, it's back in my lap, sort of like a slow tennis game. And then once I file the 3rd brief, then it's back in the court, and then they take the time it takes to study the case and render opinion, which, you know, varies, again, depending on the case, but sometimes up to a year.
Thank you.
Yeah.
Yeah, actually, I appeared in court yesterday at a superior court. So you do, as Ms. Gray clarified, juggle numerous cases, anywhere from, say, 5 to 20, just depending upon how big those cases are or how little and what the issues are in those cases. I think it also depends on your capability and your level of experience. I'm a fairly new attorney. I've been practicing for almost 3 years now, so I don't have a large of a docket as a lot of my coworkers do who have a lot more experience. So it kind of comes with time.
Thank you.
Yes.
Hi. I was just wondering where you draw the line on premeditated murder, like the time that people can take to think it through, if it's like 10 minutes before and that's considered premeditated murder, or if it's a couple weeks before. Like, or how do you know that it's premeditated if it's only an hour or so before the incident occurs?
Kathleen?
It doesn't, there is not a clear line. It's premeditation and deliberation can occur quickly. It can occur in just a matter of minutes, or it can take weeks. It just depends on the facts of the case, the situation, the person involved, and that's pretty much what the law is. What are the facts, and what did happen here? And did someone premeditate, or did they act rashly through pure emotion?
For the judges, what was the process to get to the position where you currently are?
Sure. We all took different roads to get there, but to be a judge, they look for people with a variety of backgrounds. It doesn't, you don't have to just have criminal experience or civil experience. They'd like you to have a little bit of everything. I had primarily, in fact, exclusively civil experience. You have to be a lawyer for 10 years before you can be considered to go on to the Superior Court. You're appointed by the governor, or if there's an open seat, you can run, and our terms are for 6 years. It's interesting, around the country you have different forms of how you get to the court. A lot of particular states, even at the Court of Appeal level, have elections. There are good and bad things about elections, because I think you've seen in some states where literally millions of dollars are put into judicial elections by various sides of issues, which is problematic, because as a judge, we have to apply, and it's our duty to apply the law to the facts. We don't come to the bench representing any entity. We don't run for the bench or say we'd like to be on the bench to represent defense interests or prosecutors or oil companies or consumers. We have to be very careful, and I know we all are very careful, to always look at the case in an impartial manner and apply the facts or the law to the facts. So it's different here in California, that they try in the governor's office. I know Governor Schwarzenegger appointed, I think, about 600 judges during his 2 terms. What happens is the governor oftentimes in a particular area will have a judicial selection advisory committee made up of judges and lawyers who review those folks for the governor and talk to people, talk to fellow attorneys, talk to judges, and see what type of judge that individual might be. You want to make sure that you have someone who's fair, who's an even-handed individual, who's not someone who flies off the handle, and that can just be the type of judge that we all want to have on the bench if we happen to be on the other side and have a case before that judge. The state bar also has a procedure called the Judicial Nominee Evaluation Commission, where they will oftentimes send out 500 or 600 forms to attorneys and individuals across that district asking for information about that person. And then they will sit back and evaluate that potential judge candidate. And you filter out a lot of people that way, because if someone has been the type of attorney that plays fast and loose with the facts or is not always honest to the core, those issues and those attributes become readily apparent to their colleagues. And the state bar will find out about that and then report that to the governor as well. So here in California, we're, I think, very fortunate to have a lot of safeguards in terms of judicial selection and retention. And once we, I should note that once we're appointed to the Superior Court, it's for a 6-year term. And then it's a longer term for the Court of Appeal. And on the Court of Appeal, we don't have people running for the Court of Appeal. We have retention elections where people vote as to whether to retain us for another term. And that's a process that I think is a good one, again, so that you don't have various interests running for important positions like the Court of Appeal. For instance, you will be seeing and have seen what's going on in Wisconsin. There's some very heated issues going on back there with pension reform and public employees. And the two sides of that issue decided that they were concerned about the sitting Supreme Court justice. And so someone ran against that Supreme Court justice saying, I'm going to represent basically the employees. And that should give anyone pause, because you don't want a judge running, basically signaling to everyone, my position is such and such, knowing full well that if you're on the other side of that issue and that judge wins the election and that judge is sitting up on the bench when you come before that particular individual on the other side, you have every right to think that you won't get a fair hearing, and you probably won't in some states. So again, we're very fortunate in California. That was probably a long answer to a short question, but
Hi, my question goes to the justices. In cases of homicide where the defendants plead insanity, where is the line drawn? Because, I mean, I know there's mental evaluations and such, but couldn't any act of murder, like deliberate planned murder, be considered insane?
Well, insane.
Mention insane and they look at me. So, in answer to your question, there's one body of thought that anybody who commits murder is insane. So that's one extreme side of the argument. But again, that's a fact-driven thing, kind of like the premeditation we mentioned before, where one set of facts can lead to a conclusion under the law that the person was not aware of what they were doing or aware that it was right or wrong, therefore they're not legally responsible for their act. Those are the legal definitions. And that can fit into any one of a number of different facts or not fit into any one of a number of different facts. So it really is on a case-by-case basis, and frankly, it is subject to the quality of the arguments of the counsel and the predilections of the jury. So there is no hard and fast system, there is no bright line rule, and frankly, I don't think we should have one when we're dealing with human affairs such as that. So I hope I've answered your question, but there is no hard line rule, bright line rule as to when you're insane, when you're not insane, when you're legally responsible, and when you're not legally responsible. We have legal principles, and then they're applied to the facts, and sometimes you get uneven results.
I know there was someone else, a hand. Did you still have a question, somebody? No? Any other questions? Oh, good.
This is for the lawyers. I was wondering, how do you get a case? Like, does someone come to you, or do you just get it?
Well, I'm a private attorney. I have my offices in Monterey County. So I'm on several panels throughout the state. I actually take cases between here and Orange County. And actually, not here, but Orange County and the border of Oregon. So I have cases throughout the state. So I'm on a variety of panels, and I just get appointed, and my work is evaluated every time by attorneys. Sometimes the court will, if they particularly don't like something or particularly do like something, they might mention something to the panel, not me directly. And so we are appointed by the court to represent the indigent client. And you'll find that even if a person who's convicted of a felony, all these crimes that we argue are felonies, for the most part, unless for some reason it turned out to get judged as a misdemeanor. In a few instances, you'll see a few misdemeanors up here. But so the court appoints me, but I'm actually working as an independent contractor for the state, and the court makes the appointment based on recommendation of a private panel that's run by attorneys who evaluate your qualifications and your work as you go along, and you get sort of go up the scale in terms of type of cases you're offered and how many cases. And as far as Ms. Jacobs, she works for an office that is, she's an employee of the state, the Attorney General's office. And, you know, there's pros and cons to both sides. And I was mentioning some of the cons to my husband on the way down here. But if you work for the state, when they don't have a budget in the summer, they get paid, and I don't. So, but one of the pros of doing what I do is I get to, you know, being a defense attorney, I get to argue what I believe are important issues about personal freedoms and the way the state interacts with its citizens. So, you know, I like that. And I also have a little bit more freedom in terms of, you know, I have responsibilities to the court, but once those are taken, I can, I don't have to be in an office necessarily, you know, looking like an attorney every day. People frequently run into me and ask me if I still have a job because I work, you know, my clients are incarcerated, so they're not coming to me in an office. And so that allows for what some people refer to as bathrobe warriors. So, but in any event, that's pretty much how it works. I have been offered several cases. I get letters frequently from, I have a whole file of people that write to me from prison. I heard about you from my cellmate. I heard about you. I saw this case that got published. Would you represent me? And I generally don't like to take private cases. I prefer having just the appointment. There's several reasons that I won't go into detail, but it usually works better that way for me.
As Ms. Gray said, I work for the state. My title is a Deputy Attorney General. So I represent the Attorney General's office on behalf of the people in the appellate process. And as far as what cases I get, I have so many bosses up the chain of the ladder that decide who gets what cases on numerous factors that I'm not entirely aware of myself. But I do get assigned particular cases that perhaps there was a co-defendant in this case, and I've already done briefing on the co-defendant in order to save money, and for the sake of efficiency, I'll get a brief from a co-defendant for the same facts. So.
And your top boss would be Attorney General Kamala Harris, and if the radio was accurate, she's in your area today, or will be. That is, if NPR got it right. And so if you see the name Kamala Harris or read about any of her issues, and I know she's down talking about some gang-related issues in Tulare County, you can think about Ms. Jacobs and say, you know one of the attorneys that works with her. But that's how the connection works. Yeah.
I just wanted to follow up on the two questions about definitions of premeditation and insanity. In this case you heard today had to do with instructions that were given by the trial court to the jury before their deliberations. In an issue where there's an issue of premeditation or insanity, the trial judge reads a definition and gives factors that make up the definition of premeditation. The jury's job is to take that definition that the judge gives them and apply it to the facts. So there isn't a bright line, but they are given a definition and some factors to look at, so they're just not shooting in the dark, so to speak. So that's really kind of how it plays out.
Yes, I had a question for the justices. I know today's judicial system isn't a perfect system. Like most systems, it's not. In your opinion, could there be anything that you could do to make it easier on the people who deserve an appeal? Things like denying an appeal to somebody whose evidence is so large against them that you can, along with, not giving them a possibility of parole, giving them not a possibility of appeal.
Well, I'll try that. There are a lot of different judicial systems in the world. As I understand, and I'm no expert on it, Japan has a system that is sort of interesting to the extent people are entitled to an appeal and to have counsel, but if they don't prevail, they don't get time credit for while their appeal is pending. So it creates an incentive to think really hard about whether you really want to pursue your appeal or not. I believe it's Japan. I'm taking a risk here, speaking a little bit off the top of my head, trying to recall a course I took in comparative law 11 years ago. I'm trying to remember what I did 11 days ago. But that is an example of a way to address the types of issues that I think you are. Many of us believe that we don't, as you say, have a perfect system, but it is about the best that we can come up with. And in the civil arena, at least, there have been other ways of trying to resolve cases short of litigation. So there have been practices develop in mediation and arbitration and ways to try and get cases resolved before they go to court to try to save money, because the last thing we want is for the system to become one that is just for the wealthy, and so that everybody doesn't have equal access to justice. I don't know, does anybody else have comments?
Well, along those lines, we've worked statewide on initiatives like Spanish self-help centers and other self-help centers, because so many people nowadays cannot afford attorneys, and yet they have to come into court. They don't know the process or procedures, and it's difficult enough for a new attorney, let alone someone who doesn't have legal training. And so the courts have instituted a number of programs to make it easier for people who need to get into court, who may have a family law matter, who may have a juvenile dependency matter, just to figure out what to do and how to proceed. And we have an online resource for folks that gets literally millions of hits a year from people around the state trying to figure out, and they can, in large measure, figure out how the court system works and the processes and procedures that they need to follow. It's interesting, we do have a wonderful court system, and certainly here in Tulare, you have the Tulare Superior Court, which is one of the hardest working courts in California. That's the good news in terms of how hardworking they are. The bad news is they literally have so many people coming through their court that sometimes they and other courts around the state feel almost as though it's an assembly line. They have so many cases, and when they're facing this year, as in past years, a budget crisis that obviously is hitting everyone, they have to figure out how to do more with less. The problem that we have in government is that we can't, for instance, at the Tulare Superior Court level or Fresno Superior Court, say that we're not going to handle probate this year, that it costs a lot of money to have a probate division because you have to have investigators and analysts and the like, and so we just won't do that for a year to save money. We have to take every case that comes through the door at the Court of Appeal level and at the trial court level. Juvenile dependency matters, family law matters. People's lives depend on us taking care of these cases in a timely fashion. And so that is one of the things that, we pride ourselves in handling the number of cases that we handle at all of the Superior Court levels. But as you listen to what is happening statewide and seeing the various budget priorities that are out there, I hope you understand that if the lines get a little bit longer, or it's a little tougher when you're on jury duty because they're juggling so many cases, things are very difficult for the courts because it's not an easy fix, given that everyone who walks through the door deserves and is given their time in court.
That raises one other thought, too. There is a technique that I've seen some counties engage in our district, which, of course, it's plea bargaining. That happens everywhere. But I've seen certain counties will have an individual give up their right to an appeal in exchange for maybe having a more favorable sentence. So that's a technique that has been used, and that cuts down on the potential for the number of appeals, too.
Your question seemed to be a philosophical one. And if I interpreted it correctly, you seem to indicate that there are some cases where the facts are so bad that those persons shouldn't have a right to appeal. And that causes me to bring up, you need to step back and understand what our system is based on philosophically. There is no right to appeal in the United States Constitution. That is a creature that has been enacted by legislatures and people through propositions throughout the United States. And the entire criminal justice system, the way it's set up, including the burden of proof on the prosecution and beyond a reasonable doubt, that's not in the United States Constitution. Okay. All that has been added on. All of that is designed for one purpose, which is the presumption is that everyone is innocent until proven otherwise. So that means your system is going to be built around maybe accommodating a lot of bad people abusing the system to make sure that the innocent person doesn't get, you have a message or something?
Oh, no, you
Okay.
finish.
So that an innocent person doesn't get convicted. You've all read about people that have been on death row where they have been discovered that through DNA evidence that they were innocent after they've been there for many, many years, and frankly, those are failures. But if you deny the right to appeal, then those cases are less likely to be found and those people are less likely to be released. So it's a heavy price to pay, where on the one hand you have to put up with a number of frivolous appeals on one side in order to protect those people who have a legitimate concern. Because sometimes on the face of it, it looks pretty bad. You can have a horrible set of facts, but if you got the wrong person, those horrible set of facts shouldn't deny that wrong person the right to have their day in court. And the bottom line in all of this is if you don't like the system of laws, then change it. For example, when I say we are built on a system of laws, if you don't like Dennis Cornell, go out and get a constitutional amendment that I be summarily executed. That would be allowed if you did it correctly, much to my chagrin and disappointment. But that is as simple an example as I can give you, is that we're a nation of laws. If you don't like the law, change it.
Do you have any questions yet for the attorneys? Remember, you were asking about all those cases that they're working on, and they need to get back to them, but they would be able to answer some additional questions if you have some for them. Yes. And these will be questions for the attorneys.
I was just wondering, do you ever defend someone who you think is guilty?
I expect. I always tell people I've had some pretty, quite frankly, awful cases. I've taken cases up to life without parole, and I have some defendants with 500-year, 300-year sentences. So as far as whether or not it's guilty, that's not really, I was not at the trial. I'm not the judge. My job as a defense attorney is to ensure they had a fair trial. I review the entire record. Did they have competent representation? Was their defense adequately presented? And I don't want to discuss today, but you saw what I did today in terms of what were the legal rights and the law properly presented to the jury. So it's not really a question of guilt or innocence, because that's not really my decision. And so I never ask clients, are you guilty? There's really no reason for that. And my own opinion is really irrelevant to the job I have to do. So, you know, whether or not I think they are, it doesn't really matter because that's not my job. And there are some people that have gotten 50-year to life sentences that, with the proper representation on appeal, have gone to a misdemeanor and gotten 3 months in jail. So, you know, was that correct decision? Well, under the law, yes, it is. And you know, I'm proud to have the skills to do that. And since I do speak Spanish, and I lived in Mexico for a while, and I was forced to speak it because nobody would speak English to me. I have a lot of clients that are underrepresented, and I see cultural defenses. So I think a lot of the legal challenges that I have are sort of sometimes the friction between our culture or the majority culture, the United States or California, or the culture in power, and the culture from people from other countries, and many of whom speak Spanish. I've had people that speak Japanese. I have an Israeli citizen now. So it's, you know, it's very, what guilt is a very, it's a very kind of amorphous concept. So anyway, it doesn't really play into what I do.
Other questions for the attorneys? I think we had some. Yes.
What would one have to do to become an attorney, like education-wise?
Well, California, I believe, last time I checked, was one of the few states where you can just take the test. It's called writing for the test. I believe you have to work for a certain number of hours with an attorney. I have never met a practicing attorney that's done that. I believe there are some. But the traditional way, the way I went to 4-year college. I graduated, and I went to law school for 3 years. And then I passed the bar first time. So I went to Hastings College of the Law in San Francisco. I highly recommend it.
One of the best law schools in the world.
He went there too.
There are a few Hastings up here.
And
So
if you don't like law school, there's always San Francisco. There's plenty to do there. So, it was a challenging time, and so it's basically 7 years. And I recommend I worked for an attorney while attending law school, and he's actually one of my best. He's like my second father, I call him. He's turned into my mentor and one of my good friends. He's about 20 years older than me, and I got a lot of practical experience very early. And in fact, did my first jury trial, not a jury trial, but a court trial, 2 weeks after I was sworn in to the bar. So, you know, I kind of landed in it feet first, so that's really the way to do it as far as I'm concerned. And fortunately for me, I won, or fortunately for my clients anyway.
I actually am not from the state of California. I went to law school at the University of Montana School of Law, and there's only one law school in that state. It was a very, very small school. I had about 75 people in my graduating class. So it afforded me a different opportunity than most. My third year of law school, I worked at we were required to do clinics, and I actually did a criminal defense clinic in order to gain perspective and some experience on the other side. And I had the opportunity to actually argue in front of the Ninth Circuit Court of Appeals my third year in law school on the defense side. So law school, I think, you should open your horizons to outside of the state would be my recommendation. And just keep in mind that California, while it's a good idea to go to law school in the state where you plan to take the bar exam, and there are numerous law schools here, that there are other law schools too that might serve what you're looking for.
Other questions for the attorneys? Okay, then we're going to excuse them, and please give them a hand once again for what they have done. Thank you, Professor, very much. All right, additional questions. You're stuck with all of us now, so.
I wanted to make a comment, if I could, on the issue of right to appeal and things of that sort. As Justice Hill said, I've been on this court for about 3 months now, and I came from the trial court. And to give you a description about what the trial judge does, the trial judge that had this case you heard today, I'm sure handled it the same way most other trial judges do. And it's like the attorney said, they have to juggle balls. Generally speaking, they get to court 8 o'clock or so, and they have matters that they have to decide between 8 and 9. Then at 9 o'clock, they go out and they continue with their jury trial. Then at noon, they recess, and they have to read papers that have been given to them during the day. Come back at 1:30, they continue with the jury trial. Then at the end of the day, they have more hearings on other totally separate cases. Then they have to come back the next day, and they talk with the lawyers about the jury instructions that you've heard discussed today. And they do these things, and they make probably 50 to 100 decisions every day on a variety of cases, not just one case. The case ends, it goes on appeal. When it gets to our court up here, we're handling 5 cases personally a month, 10 that we help on, so we have 15 cases, and we have a couple of months to think about those. And we have a quiet room, nobody interrupts you. I can go weeks without seeing some of my colleagues. Nobody's calling you, you don't have your email coming in anymore, and you are there for one purpose, to make sure that some error wasn't made by the court or by one of the lawyers, recognizing again that the judges down there are just as smart as the judges on our court, many times are smarter. But when they have so many decisions to make and they're under so much pressure, and that's where an error can be made. It's not intentional, and that's what the Court of Appeal is there for, to make sure that there wasn't an error that affected the outcome of the case. And that's why people do have the right to appeal, because I think the numbers are this: about 10% of the criminal cases are reversed on appeal, and about 20 to 25% of the civil cases are reversed on appeal. So errors do happen, it's human nature, and that's why we have an appellate court that has the time and the resources to sit back and have a lot of hands and minds looking at the trial. So maybe that's just an explanation for you.
I want to complain to the presiding justice. If he's only handling 15 matters a month, then the rest of us are way overloaded.
That's right. I'm new. I'm learning.
Oh, we're working him up to it.
Hi, I have a question. Can a proceeding or the presiding judge of the initial trial ever find his way on the Court of Appeals? Or is that a conflict of interest? Like if he was involved in the sentencing?
I can tell you that right now. Since I've only been here 3 months, my colleagues, they don't talk to me about it because they can't talk to me about it, but I've been reversed a few times as I'm sitting on the Court of Appeal on a case that I handled in the trial court. But once I get to the Court of Appeal, I cannot touch that case. I can't talk to anybody about it. They can't talk to me about it. We keep everything separate. But it's a little embarrassing when you get spanked by your colleagues for doing something wrong. So.
Yes. Oh, yes.
Basically, you brought up the fact that you reviewed the lawyers entering information. You also reviewed the law enforcement, those who work for the lawyers, to help support their case. You look at evidence submitted by them, possibly it was wrongfully submitted or withheld.
It has to be submitted by the attorneys.
Okay.
It's part of what they call the official record that came out in the course of the trial or some preliminary proceedings relating to the case. Then the Court of Appeal looks at it. But if they don't initiate any new discovery, we don't say, I want to send an investigator out to have somebody interviewed that maybe wasn't interviewed before. That's not done. Everything has to come through the lawyers, and everything they bring has to have been part of the official trial court record, so to speak.
So then they could enter in, I guess what I'm saying is basically they could bring to light maybe some new evidence found.
Try.
They can try, okay.
There's certain exceptions.
Not at our level. We deal with what was in front of the trial judge. Okay. So everything has to be proved. Whatever happened in the trial court, that's what we review. We don't take evidence We don't hear witnesses. We just review what happened in the trial court. As you all know, imagine there's some of you that came here today expecting to see some witnesses called. We don't do that. And when you see it on television, I'm going to appeal. What they really want is they want the Court of Appeal to find that all the witnesses against them were liars. We don't do that. What we look for is legal error that had affected the outcome of the trial. So all of what you're talking about has to be presented to the trial judge in the first instance.
Justice Cornell is absolutely correct. The only time I've ever seen it come up is we also hear things that are called writs. And occasionally we'll get a writ of habeas corpus that will come up. And the example I think of most commonly is where there's a claim of ineffective assistance of counsel. You may have heard we talked a little bit about that with the attorneys. And under those circumstances, we will sometimes have a letter sent to the attorney that represented the individual and have them explain why they did what they did, which is in a way taking evidence. But that's a very unusual situation.
So it's very rare.
It is,
Okay.
yeah.
Thank you.
You bet. And we had a gentleman with a microphone.
I just have a question. I'm curious to hear you guys' answer. Wouldn't you say that a judge that's appointed by, say, the governor is just as biased as someone who's elected? For example, a judge selected, appointed by the governor, has some political alliances.
You're assuming a fact, not an evidence, which is that the judge in the first instance is biased.
And let me tell you just how our last governor made choices. You know, when we talked about that Judicial Selection Advisory Committee, I was on that committee. It was equally divided between, there were Democrats and Republicans, and during the entire course of that committee, we probably were in existence 6 or 7 years, not one time did we discuss anyone's political philosophy, any applicant's philosophy on anything other than is he or she the type of individual which will be a good judge. And that was our goal at the start, not to talk about political philosophy or the like, and it never came up throughout the entire process. We were proud of that. And if you look at what happened over the past 7 years, there were, just almost as many Democrats as Republicans appointed to the trial bench. So, it's not, again, in some states it's quite different, but I think in California a goal should be, and is oftentimes, just to find the best person and not to say, well, my pool is now limited to Republicans because I'm a Republican governor, or my pool is now limited to Democrats because I'm a Democrat governor. It needs to be the best person out there for the job, and I think that's the trend certainly in California.
Other questions? Yes.
My question was, I understand that this court deals with rules that have been broken during the course of a trial by a judge or a lawyer, but in order for a case to come before you, is a requirement that the rule that was broken would have the potential to affect the outcome of the trial?
Absolutely. The California Constitution provides that appellate court cannot reverse a decision unless the error that was discovered affected the outcome. There has to be a miscarriage of justice. And so it's not enough that there is some technical or even significant legal error unless, in the court's view, that affects the outcome of the case. As has been mentioned, trial judges make dozens and dozens and dozens of decisions in trials and proceedings every day. And, imagine if every decision you made, you had 3 people months later applied a microscope to see if they agreed or disagreed with your decision. Over time, you would have some of those people looking over your shoulder saying, well, I wouldn't have made that decision, or I think that should have been this. So that's very common that people that oversee others will find decisions that they don't agree with. But the ultimate question is whether those errors rose to the level where it was likely to have affected the outcome. And only then will we reverse the decision of the trial court.
Any other questions?
What's the most bizarre set of facts or bizarre set of facts or error that you've seen while you've been on the court? Except for the gentleman who's only been there for 3 months already.
That is well, I don't know if it's, yes, and it's old. Well, it's the case that sticks out the most in my mind, let me put it that way, and it's so old, it was a long time ago. I mean, because I've been on the bench 25 years, something like that. Anyway, it was early in my career, and there weren't many women that were attorneys, and I was the only female judge. And I'll never forget it. It was in a courtroom that was circular, which is kind of a funny shape for a courtroom anyway. But it was a circle, and I was in there, and I was the only woman in the entire room. And the court reporter was male, the victim was male, there were 3 male defendants, and they were all represented by male attorneys. And it was an awful case. It was a young man who was raped in jail. So it was an issue where oftentimes at that point it would be a woman's issue, where women typically were ones where you would see them come in as victims. And to have a young man who was there, I actually thought it was fortuitous that I was the judge, because I felt that he was miserable, and the defendants were making faces at him, and I thought it was probably easier for him to tell me the story than it might have been to tell someone else. I'll never forget that case as long as I live. I was just hearing a preliminary hearing, which is not a jury trial, so all I was doing was listening to evidence to determine whether there was enough in order to bind it over to go to Superior Court, like what Justice Franson was talking about, and then he would have gotten it for trial. I was a municipal court judge at the time. I don't know if that fits your criteria.
I was wondering, as a court of appeals, what you all have heard as what would be strange or unusual to come to you as a group.
We get so many, it's hard to describe. It really is. We had one where a gentleman was representing himself, and he sued the county because the bathroom that he was at the courthouse was dirty. And we have cases, that we have them that are incredibly mean and ugly and show the evil side of human beings. We just had one of those recently, which was the facts were beyond description. And we have dependency cases where houses and parents, the way they treat their children are beyond description. So I don't know if I can isolate any. I think the most famous case I had was as a lawyer, and sorry I can't repeat it in public, so because of the nature of the case. But we've seen everything, or just when we think we've seen everything, we get something more bizarre.
Some of the funny things we've seen, we're at a court of appeal, and we've had attorneys come in who may have been trial counsel for the underlying case, and they forget they're at the court of appeal. They think they're still arguing to the jury. And we had one very experienced lawyer came in, and he's very experienced trial attorney, and pretend the jury would have been sitting over here. So he's arguing to us, and then he goes, and ladies, and then he takes his hand like this, like he would be talking, ladies and gentlemen of the jury, and then he remembered, oh, wrong court. That was kind of funny. I remember that.
We get a lot of writs of habeas corpus from prisoners, raise all sorts of issues about their incarceration, and maybe you've read in the paper about litigation that has gone on for I don't know how many years now about medical care rendered to prisoners by the state. We had one 2 or 3 years ago where a prisoner filed a writ of habeas corpus over some dental issues that he had, and he was seen by the dentist. It was determined that he had an abscessed tooth. He was then referred to an oral surgeon who obtained his consent and removed the tooth, and he had a full and complete recovery. But he still brought the suit because he was very upset that they had not saved the tooth for him to keep. We get things like that all the time.
We also have serious cases.
Hi, I just want to thank you. I'm on the TCOE board here, and I'm new too. But I do have I watch a lot of TV, and you hear where appeals are constantly denied, and yet today you talked about your private time you have to review these cases. How is that handled? I mean, do you do it as a group, or is it just one? I doubt if in America just one judge reviews these requests.
Every case that comes to this Court of Appeal is reviewed by 3 judges, and the decision is always in writing. Now, the writing may consist of writ denied. The writ denied is still in writing as opposed to being delivered orally. Different courts operate different ways, but in California at the appellate level, every case is decided by 3 justices. Generally, one judge is assigned the duty of initially working up the case, and then the other 2 judges sit and review the work product and comment and make changes or dissent or concur depending on what they want to do. Not all courts of appeal in the United States work the same way, but that's the way the Court of Appeal in California works. The United States Supreme, and this all happens generally before oral argument. We have all, like on cases we had today, we've all discussed this case in advance, so we were all generally aware of where each of us felt the case issues were and so on. But the United States Supreme Court operates differently from any court in the United States. Each judge on the United States Supreme Court works up every single case by themselves without any consultation with any of the other judges. And then after oral argument, they take a vote. And they discuss the case and take a vote after the oral argument. So they literally are 9 separate courts that rule by majority vote. It's a very inefficient way to do it, but remember, they only work on 70 to 80 cases a year, and we work on literally thousands. So there's a wide range of how things can happen. I hope I've answered your question.
Oh, Charlene? Charlene, we have a question, at least one in the front.
I just wanted to ask, if there are preliminary hearings to establish evidence, can they still appeal on whether or not there's sufficient evidence for any case?
You mean, are you using the term preliminary hearing in the context of having a magistrate hear the case, then determine whether there's sufficient evidence to bind a person over for trial?
Because I believe that there were hearings before any trials to establish evidence, and then I assumed that after they established the evidence, they went into trial.
Right. Yes, most criminal cases that are felonies are charged and they go to what is called a preliminary hearing. That's the kind of case I was explaining about that happened with the young man that was raped. And but you can appeal, but you don't appeal, you take a writ. It's a fairly limited ability to proceed. But let's assume someone gets bound over for trial, and the attorney representing the individual who was bound over can bring a writ and seek to have an information, which is the charging document, set aside because their argument normally is there wasn't enough evidence presented at the preliminary hearing. And so we could consider that not as an appeal, but as a writ. I hope that is answering your question. Yeah. Yeah. That's usually how it works. The case that we heard was following a jury trial, which is more typical, yeah, much more typical. Other questions? You guys are great. Well, maybe we have some questions for you. How many of you would consider becoming attorneys? Great. And if you're comfortable sharing with us, why don't you let us know what if you could pick any area of law that you would like to practice in, what do you think it would be? Any ideas?
I would like to do criminal myself.
Be a criminal yourself, you said?
Just a little bit longer, I might look like Jeremiah Johnson.
There you go.
Or Abraham Lincoln.
Yeah.
No, I want to go into, if I were to pick a specialty in law to, go into, it'd probably be criminal law. Actually, I knew a gentleman here who worked for the DA, Mr. Peter Champion, who tried many different areas of law. He finished retired in family law, but he said he enjoyed the white-collar crimes department the most because he liked basically kind of sticking it to the guys who thought they could get away with things that the average person could not. Which I respect him and I understand that because sometimes there are people who feel that they're smarter than others and they'll use that intelligence and their gifts that they were given and born with to try to take advantage of people.
That's right. We've had some very prominent media examples of that, have we not? Bernie Madoff, and the list goes on. Yeah.
At least those that we saw, there's probably more.
Yeah. Always more. Tip of the iceberg. Other thoughts about what areas of law, if those of you that had the courage to raise your hands. No? Okay. Should we introduce our Superior Court judge?
This is the time to do it, open season on the judges, so let us have it.
And
If we can't answer it,
see,
I'll tell you we can't answer it.
our business is to have opinions, so you can just count on the fact that we'll give you them. So, yes.
I think this is a wonderful learning opportunity. Are there any other examples of this where individuals, I represent the city of Visalia, and we have a program called Citizens in the Know, and just educating the public about the workings of local government or the criminal justice system. This is a wonderful opportunity, and the dialogue is terrific. Are there other opportunities that are available, and how do you become aware of those?
Oh, I bet if you asked your district attorney to come to your government class, he'd be happy to show up, or your public defender, and answer questions. Police chief, sheriff, the fire chief, all of these people who are in public service and are leaders, city manager, so on, would be happy to speak to your groups either individually or as a collective group such as this.
We would invite you to come, your classrooms, if your instructors can pull it off, come up and see our court. It's a brand new building and it's absolutely beautiful. It really is. Its theme is Yosemite. One of our biggest problems we were talking about is, it's so beautiful you can get distracted during oral argument because you like to look at the scenery. But please come.
When I was on the Superior Court, I used to encourage high schools to come in small groups or large and watch a trial. And I would get somewhat organized, and before they would come, I would give them a little summary of what the proceeding was going to be that day, picking the jury, opening statements, and 15 or 20 people would come, and by the end of the week, there were probably only 5 or 6 left because the other people had something to do. But the ones that stuck around, I think they learned a lot and found it absolutely fascinating. And pretty soon, the lawyers got to know these people, they got to know the lawyers, and during all the recesses, they were all talking. And in the end, I think it was a great educational program and experience for them all. So you don't have to be invited. Just show up on a Monday morning in a courtroom here in Visalia. You could probably watch a trial.
We're
Wait, we had a question?
Oh.
is open to the public or whether it's a closed case?
The trial is always open to the public unless the judge specifically says otherwise, and there are very, very strict rules about when you can close a public hearing. That's in the Constitution. It has to be an open and public trial.
Unless it's a juvenile.
Unless it's a juvenile, when you're not an adult at that point. And there's a move afoot to have the juvenile cases be made open to the public right now. So that may also be open to the public. Abraham?
Why is it that court cases are not televised or the recordings aren't made available in a timely manner, or that you yourself cannot make a recording of a case?
Interesting. You know, you'll find that in federal court a lot. There are a lot of restrictions that the federal court has in terms of televising. Those same restrictions are not present in trial courts across the state. There were some occasions where, you know, it's obviously up to a judge on a case-by-case basis, and there's some, you know, decisions that, you know, the attorneys will weigh in on those cases, and the judges will make the ultimate decision. But in California, I think you'll see far more televised cases than you will, you know. Are there any federal cases that are televised now that I know of? They're looking into it. But I think oftentimes that it's a good educational tool when people see that. I remember I had a case, I was a relatively new judge, and I don't know whether Court TV is still around, but it was going to be broadcast nationally on Court TV. It was a case where it was a very interesting case involving a gentleman who hadn't gotten his brakes fixed on his pickup, knew he needed to get them fixed, didn't get them fixed, and wound up running over a child and killing the child. And he was being prosecuted criminally for doing that because his brakes didn't work. What was interesting about that is we had two brand new attorneys who had never had a jury trial in their life. And they were going to be on national TV. And the public defender said, I can hardly wait for my boss to be watching me on national TV in my first trial. And I must say, this particular public defender, not only was she new, but she said the first thing that popped into her mouth, always. Sometimes occasional profanity, and oftentimes very offensive things to the opposing attorney. I was working with her on that, and we certainly stepped up the process of working with her before the national television cameras came in. We were all holding our breath for about 4 days, and it worked out well. And I must say, my experience has been, I know that there's some people who are concerned that attorneys and others will play to the cameras. I never really had that. You know, the cameras you can get a pool camera in the corner of a courtroom. You don't have to have 5 cameras set up. And it's inconspicuous. And after about the first couple of hours, everyone just forgets it's there. And I think it's a good educational tool, and I think when people see what goes on in a courtroom, it demystifies the process and makes people, I think, feel good about our legal process. So hopefully we'll start doing more of it, but I think in California we certainly are at the forefront of that.
Thank you.
I think we may have another question. Is that it?
Do we have a question from, oh no.
Oh, okay.
Okay.
I thought we had a special question here. Thanks.
Yeah. Any,
I was just going to say that this court, we cover 9 counties, Kern County in the south, Stanislaus in the north, and Tuolumne and Mariposa to the east. And we've been to every county in our district and had sessions such as this. This is the second time we've been here. And as I understand it, we pride ourselves on just letting you ask questions. We do not require that they be pre-screened. We don't require that they be in writing. And that, I think, is unique anywhere in the United States. So I encourage you to take advantage of it.
I just have a question about the death penalty, actually. The United States uses the death penalty really sparingly, and I know in other countries like Singapore, for example, they hang people for really minor crimes in our case, but they seem to have lower crime rates. From what I understand, that may be incorrect information, but do you think that an increased use of the death penalty would deter crime, or no?
Go ahead, Jennifer. You haven't talked in a while.
Oh, yes, look at me. He's looking at me because prior to coming to the bench, I was a prosecutor, and I prosecuted homicide cases. In California, the death penalty is only available in homicide cases, and a lot of people don't know this, but the death penalty is only sought if the district attorney chooses to seek it. So in California, in order for the death penalty to be imposed, it has to be a murder. The jury has to find that it was first-degree murder. The jury has to find that it was first-degree murder with special circumstances, and the district attorney has to choose to seek the death penalty. So in California, that's the only time in which the death penalty is sought. Does it reduce the crime rate? If you want to know my personal opinion, after having prosecuted many, many homicide cases, my personal opinion is no, it does not. If someone is going to commit a first-degree murder with special circumstances, the last thing that person, from my experience, the last thing that person is thinking about is, could I get the death penalty? If I could, maybe I won't do it. That's not going through their head. So I don't think it reduces first-degree murders with special circumstances, but that's just my personal opinion.
Well, the other side of that, though, is that in California, for the last, I don't know how many decades, the death penalty has not been carried out in any type of diligent fashion. I mean, if you go back 50 years, if somebody got the death penalty, their appeals would be exhausted within 2 or 3, 4 years, and it would be carried out. That hasn't been true in I don't know how long. So those that are in favor of the death penalty as a deterrent would say that it's not being given a chance to be a deterrent because people that commit crimes today, even if there are heinous crimes with special circumstances, the odds of them having that sentence carried out within the next 25 years is slim to none.
Right. Any other takers on that question? Yeah. One thing, we would like to introduce the judges from your very own county that are here and have been sitting through at least most of the proceedings, if not all, and commend them for doing that, and also commend them for the hard work that they do. And in no particular order, I have Judge Walter Gorelick, yes, and Judge James Holman, and presiding Judge Melinda Reed, yay, and Judge Gary Payton, and Judge Valeriano Saucedo. Excellent, and please tell me if I've missed any of you. It's only because I don't have the name written down or I can't see you. And these are the folks like Justice Franson and some of the other justices we're talking about that are truly on the line and are making thousands of decisions a day. I know I can recall when I was on the trial bench and my husband would take me out to dinner and I would look at him and say, I can't decide what I want to order on the menu because I just made one too many decisions today. And it's just that, it is the most, in my opinion, difficult job in the system. And we thank them for being here and spending their mornings with us. And I would encourage them, if you have anything that you would like to add or any points that you would like to make, that you feel very free to do so. We would welcome them. Judge Kalation just came in too. We're not fronting you out. We just introduced everybody and didn't want you to be missed. But if any of you have, any of the judges would like to comment on the day-to-day routine of a trial judge or what it's like, how you feel when you see that red cover and you know someone's taken a writ on one of your cases, we would certainly be thrilled to have you do that.
I'll say this, it's a lot more exciting on TV than it is watching it.
Yes, that's Judge Payton. That is true. Sometimes it's like watching paint dry. Right. Right. Any others? Okay. Bradley.
I should point out, too, that we have a member of the Tulare County Superior Court with us at the Court of Appeal this past month. He is sitting as a Justice Pro Tem for one of our judges who has been out, and I think he's enjoyed the process, seeing it from the other side, and and Judge Vortman is a longtime member of the Tulare Superior Court bench and an outstanding judge, and we have enjoyed him thoroughly. We hate to give him back to the Superior Court, but we know he has to come back eventually. But it's a fun opportunity. I know Judge Kane had that opportunity a number of years ago to sit on the Court of Appeal, and others have. Justice Cornell did as well. So it's a good opportunity that we're trying to afford others. And Justice Stetchen did. I was about the only one who didn't. So it was all new to me when I got to the Court of Appeal, but I do enjoy it thoroughly. And I would just stress that, as we indicated before, and as Judge Franson pointed out, the Superior Court, when you go and see what they do on a day-to-day basis, I remember when I did the sentencing calendar, we would have about 120 cases on in a day. And as Judge Franson pointed out, your breaks are spent dealing with questions. You race back to chambers and pull books off of the shelf and try to come up with the right answer, and then race back out, put it on the record. And it is a nice opportunity that we've had at the Court of Appeal, and I always consider the Court of Appeal to be a good safety net. I did my very best, but when you have 120 cases and that many attorneys who are out there, you do just that, your very best with the time that you have, and hope that you get it right at 99% of the time, and that 1% that you don't, I was always happy that the Court of Appeal was there with a couple of months to look at it with a fine-tooth comb. So at any rate, we want to thank all of you for being here. We hope to come back again soon. It's been an opportunity that we have enjoyed. We hope that you've enjoyed it as well, and we'll stay around for a few moments if any of you want to come up and chat. With so many budding lawyers in the room, there are great law schools here in Visalia and Fresno for those who would like to stay close to home. Many of you think, well, how can I take 3 years off to devote full-time to law school after college? You don't necessarily have to do that. There are great law schools where you can take 4 years and work. You can, oftentimes people have families, jobs, and they still get their law degree and realize their dream that way, as opposed to spending, as many of us did, the 3 years straight in law school. But we'll be happy to answer any further questions. And again, thank you very, very much.
Yeah, let's do it.